A Polokwane couple slamming the country's labour laws on maternity leave. Werner and eNCA van Wyk with a civic organisation, Sonke Gender Justice, wants the Basic Conditions of Employment Act amended. They want maternity leave laws changed to allow fathers access to similar benefits and the time off. Couple is also fighting to change the definition of maternity leave to parental and caregiving leave. To tell us more now, we're joined by the family and the MPO's legal representative, Advocate Maud Letzler, who joins us from here in Johannesburg. Maud, thank you so much for your time this evening. Just as a basis for this conversation, give us a snapshot of the reasons behind, or the story behind, the Van Wyks and why they thought that there was a need for somebody to stand up and try and get the courts to acknowledge the need for this change.
Thank you. Yes, it started when James was, very young, and Werner required or wanted to take leave from work, and he applied for the ordinary 4-month leave that a mother would normally be able to take in terms of our laws. He was refused that, and it wasn't legally incorrect for them to do so, because at that stage, or still is now, a father in a heterosexual relationship is not allowed more than 6 weeks or 10, I can't remember exactly now, but they is not allowed a 4-month period of leave. So they then discussed with me the possibility of challenging the law and stating that it shouldn't be that just a mother should be forced to take leave, because eNCA has 2 businesses that she runs, and if she had taken time off from a leave, her businesses would have suffered, and she could possibly, her employees could possibly have lost their jobs if the business went to naught. So it was then decided to challenge this law to allow fathers to also have the right there too. When we started discussing the matter with Sonke, we realized that this goes further than just a heterosexual dad, and that if we look at same-sex marriages, we look at surrogacy, and we look at parents as we understand it in the wider concept, that the law does not make allowance for any of those people. And we sort of then made it an encompassing law, whereas for Werner and eNCA it was for them as a heterosexual couple, and for Sonke it goes to their whole basis of men care, and that fathers should be involved in the lives of the children.
Now, getting into the nitty-gritty, there are 2 pieces that you're looking at specifically. The one being wanting the definition of maternity leave to be changed to parental and caregiving leave, quote unquote, and then an additional category of leave, perinatal leave, it's being called, for women who do not want to take the full 4 months. Does that give us the breadth of what you want changed? And how strongly did you feel that you had a basis for the court to recognise that change?
I think the basis for the perinatal leave is specifically as it relates to the biological mother having to heal for a 6-week period after birth. So it was recognised by all of us, and in particular the research done by Sonke as well, who were extremely helpful in this matter, that there is a distinction between a biological mother and between other moms and dads. So that is where the perinatal leave comes in. In respect of the other types of leave, that is where it then includes everybody. If you look at our Labour Relations Act, it's only when it comes to the aspect of maternity where there is actually an exclusion of the male or anybody else for that matter, where it starts as focusing in the past, it was almost exclusively on the female. That has now slightly been changed by previous challenges that Sonke launched on the Act. But everywhere else in the Labour Relations Act, it refers to employee. And we feel that the equality that we seek in this country shouldn't make a distinction, and that it should be employee right throughout, with a certain different qualifications, if you know, sections that deals with the different type of parent you have. And as everybody rightly pointed out in our research that fathers already pay UIF in an employee relationship, and therefore the government wouldn't be in a financial difficulty. In actual fact, currently, dads would, or parents who are surrogacy parents or parents who are, caregivers, they all, if they are employees, contribute to the UIF pot. So it's not like there should be an out-of-pocket consideration. However, we are, I must state, waiting for the department notice of intention to defend and their affidavit before we would know what they would raise as a defense to the matter.
I was just going to ask you about that because, Maud, I mean, if you look into this case, this really is a no-brainer. Our constitution has been lauded globally as being one of the most progressive in the world. But has this just been a blind spot? Because in comparison to, I suppose you always see those articles written about how great the maternity and paternity or parental laws are for this kind of leave is in Scandinavian countries, for instance. Why are we lagging behind in tweaking this law to be more inclusive?
I think, we had, since the inception of, as you rightly say, our brilliant constitution, there has been so many other legal aspects that continuously have been challenged to bring it in line with that equity principle. And it just takes somebody to actually take it on and go to court and say, look, we want it changed and we think it is fair. And for us, it might look like a no-brainer, but the department may raise valid defences that we would have to look at. I know I saw on one, there are been some comments that why would fathers want to take that time off? Some dads don't want to spend time with children. And then there's a backlash from the dads and say, of course we want to. And then there's the question, what if a dad doesn't spend time with his child and he goes golfing all day, or what if there's, what if it's a polygamous marriage and there's more than one wife falling pregnant more than once? So there will be a lot of challenges. But remember, I think our challenge is simple. It's to say that there needs to be equality. What the regulator comes back with and the South African Law Reform Commission or whoever else tackles the bill, if we are successful, that would be, for them to hash out or for people in public to give comment on what they think, how it should be structured. And then we'll have to wait and see.
Well, I see that according to articles that are written about this, the case, the Van Wyck's attorneys, I mean, I'm assuming that includes you and that team, they've issued a notice calling on interested parties to join the application because, of course, it is a constitutional issue. Is there the belief that this might make your case stronger? Because, I mean, you could take this argument further because if you look at what is become the international norm when it comes to this kind of maternity leave, they say because we know how important early childhood development is, that if a child has or is privileged enough to have both mother and father around for an extended period of time, it only benefits the child and, of course, leads to the child not becoming a burden on the state later on. I mean, there have been many theses written about this. Is that the broader case that you would potentially look to build on this?
I think it would be absolutely fabulous if we can get to a point where, as you rightly earlier mentioned, a country like Sweden, where moms and dads both have extensive parental leave. But, one step at a time. And we're waiting to see the Section 16A notice that you referred to now, which is an invite to Amicus Curiae to join us. I know there are two parties interested today when I spoke to Sonke. So we'll wait and see. It can potentially become a case with a lot of people involved in it and with different ideas and wanting to take it further and wider. And we are excited about anybody who wants to make this a full-out, fantastic law that everybody can rely on. And we also look forward to any defence the department will put up so that we can look at ways to argue the matter that benefits all South Africans and not just those that decide to have a child.
Indeed, but as a mother of a toddler, and I'm sure many newborn mums and parents watching this right now, tell us where to sign up and we'll give you the support you need. Thank you so much.
No, I think
we're going to have to leave it there.
Much.
Thank you so much. That's Advocate Maud Letzler, who represents Sonke Gender Justice and the Van Wyk family. I'm sure we'll be keeping tabs on that story, really of interest to so many families, no matter what your makeup, as to how that case ends up in court.